trial goes to the jury. I don't know if it was the same day that it went to the jury or the day after, but it was probably the day after. And we get called back in, plaintiff and defendant gets called back in. And apparently one of the jurors has taken it upon himself to bring in a magazine article on scoliosis. So we're being asked, you know, either party can toss this juror off the jury if they want. Berkowitz is so stupid he doesn't. Now, I call this guy up later, you know, as I buy the transcripts. I look up his name, about the third one with his name was him. He says, yeah, you really should have had an attorney. I says, why should I have had an attorney? He says, well, to begin with, the initial polling of the jury, with the exception of myself and a nurse in there, they wanted to find against you for $250,000. I said, I was only being sued for $50,000. He says, yeah, but they wanted to find against you for $250,000. It took us 2 days or 3 days, whatever it was, to convince them, to try to convince them that this was a total fraud being conducted against you, but they still found against you to the tune of, what was it, like they found against me for like $13,500. And that was reduced by the amount that the bathhouse was allowed to get out from under the blanket for, so that I owed him about $7,500. Jury finally comes back with their verdict, guilty, and I'm just going, you know, did any of you people even have a brain? You know, was anybody even awake? Oh, which reminds me, during the trial, and I don't remember who I was cross-examining at the time, it was probably the chiropractor, I look over at the jury, and there's one juror right in the middle of the back row, and they were chairs. He's got his chair leaned back against the wall, and he's asleep. And I look at him, and I look at the judge looks at him, and I go, judge doesn't do nothing. I went, okay. You know, that turned out to be the foreman of the jury, by the way. So anyway, the judge, you know, the thing comes out, the judge is ready to sign the decision right then and there. I says, excuse me, Your Honor. I says, but I am going to ask that this finding be overturned for fraud on the court. And he goes, and I said, I believe I probably said, fraud on the court by the court. And he goes, well, I'll take that under consideration. So, you know, consideration. I've had a lot of these taken under consideration, advisement, I think it is, or consideration. You know, they're going to make the decision later. They're going to take it under advisement, you know, get some outside advice. Right. They're going to go back and make sure they're covered for all the crimes they've committed. That's what they had to go back, and the judge did, and which would be shown by the appellate court and the federal court's protection of the criminal activities conducted against me here. So anyways, these judges are not just protecting attorneys conducting frauds. They are promoting frauds by attorneys against the public, the property, the retirement savings, and their insurance companies. Furthermore, what this makes them is principals in the frauds that are conducted under the encouragement of this kind of protection, which is taught all the way down into law school, and is provided as demonstrated against me here. By the way, I do another, my investigation of this case, which is Nicholson versus Brailer, will continue, and then it will become Brailer versus Nicholson when I sue the six judges for racketeering in federal court. So anyway, the next thing we're going to discuss is the appeal. I'm going to go over to the appellate court, and we'll continue there. So anyway, I decided to appeal the matter, and I'm going, God, this is going to be great because I'm going to be able to check out what kind of protection the trial court judges were expecting conducting their criminal activity under, because they could not consider for a moment, especially in light of my asking at the close there, Like I say, they could not possibly imagine, especially after my asking at the close, that the case be overturned for fraud on the court by the court, that I would not appeal this matter. When you first file your appeal, you've got to do it within a certain amount of time, and what almost nobody knows is that you have to put up, you're asked to put up 1 1/2 times whatever you are found against in a bank account that basically you don't get back if you lose the appeal. So you got to put up 1 1/2 times what you're found against. In my case, that was, I think, $7,500, and I had to put up $13,000. This is a complete fraud conducted against me, which should have been overturned by the ruling, which should have been a jury verdict, which should have been overturned by the judge himself if he wasn't the criminal conducting the fraud. So anyways, I put that money into that bank account, and I write up my first appellate brief. An appellate brief, it's about a 100-pager. Mine might have been a little over 100 pages. Brought it in here to submit it to the court. They took it in, received it, went home. A short time later, I get a phone call. Mr. Brailer, would you please come back down to the court here, house here, and pick up your brief? Cannot be accepted. So I come down here, and they hand it back to me. And I said, what do you mean you can't accept it? They said, we can't accept it. I said, well, why not? And they said, we don't have to tell you. Just like that. We don't have to tell you. And this is, okay, they reject my first brief, and I'm arguing with this guy. I said, well, just give me an idea what I have to change on this to resubmit it. And believe me, by the way, reading, with each court, you find you have to have different size margins, different size fonts, things are done differently. You have to have glossaries, appendixes, and things like that. I took the first brief and I took it home, and I think what I did is I eliminated referring to these, I don't consider any of these people judges. I consider them robed public fucking attorneys. And by fucking, I mean racketeering their kind against the public. And so I think I went in there and, did a word search and took out all the fucking, and so I resubmitted it. Second time, same thing. I leave it there. They call me up. Come back, pick it up. We will not accept it the way it is. Well, why not? We don't have to tell you. And I'm dealing with the court's clerk at this time, each time. Whereas they brought it in, probably the presiding judge or maybe the clerk looks at it, he decides not to receive it. I don't have to tell you why. So anyway, I think it was the second time where I'm going, hey, you rejected my first one, you wouldn't tell me why. You rejected my second one here. You're not telling me why. I think I also brought it down to like 100 pages. It might have been like 120 the first time. There might have been some kind of a limitation on that, I thought. So anyway, this guy watches what's going on, and when I get on the elevator, he jumps on the elevator with me, and he says, sir, he says, I think you've got to understand, there's something you need to understand, and that is that this is the Court of Appeals is here to protect the judges and the courts from the public, not the public from the courts. Now this was an appellate, this was an attorney telling me the truth. In other words, they're here to protect the judges who are protecting the attorneys who are racketeering against our insurance companies. Okay? And this will become more evident when I explain what the appellate court does. So anyway, finally on my third brief that I submit, I put in the last page, I add a page in that basically says, and I am now documenting the fact that the obstructions of justice being conducted by the appellate court in refusing to receive my briefs. And so anyway, they take it in and they take it.